Good morning, Judge. I just wanted to check on your video and your audio.
All set?
Awesome. And I also have Barry Rosenbaum here as well.
And who is Mr. Rosenbaum?
I'm not sure. We were thinking he might be the mediator, but not aware.
Okay, you can let him in.
Okay, I will let everyone.
Let me in. Good morning.
Morning.
I apologize for the delay. The problem was obviously on our end, and I'm sorry you all had to kind of waste the last half hour.
Honor, are we on the record?
No.
Okay.
Okay. So are everybody who needs to be here is here?
Yes, Your Honor.
All right. And Mr. Rosenbaum, who do you represent?
I'm co-counsel with Mr. Hansma. I represent Dr. Prose.
All right, very good. All right, now we can go on the record. This is in the Court of Claims, case number 19-118, Thomas M. Prose v. Michigan Department of Natural Resources. And we are here on cross motions to enforce or settle a consent judgment. Let's hear from the plaintiff first.
Thank you, Your Honor. Yes, as you noted, this is our motion to enforce the July 22nd, 21 consent judgment, which was entered into to settle disputes related to property that my client owns in the Pinckney State Recreation Area. And specifically with reference to our motion, there's a provision in that consent judgment that says the DNR will grant to Dr. Prose a non-exclusive easement over certain roads that are in the recreation area. And those are the roads that lead to Dr. Prose's property, which consists of 5 separate contiguous tax parcels. And the consent judgment just says that the DNR is supposed to grant an easement over those roads. However, in drafting the easement grant, the DNR insists on a condition in the language that limits the number of homes that can be served by the easement. And the effect of this is that essentially the DNR is refusing to grant an easement without limiting Dr. Prose's ability to divide or sell the property as anything other than a single lot to a single purchaser. And that condition is not contained in the consent judgment anywhere. And it's not.
So is the provision, is there a provision that bars him from dividing his property, or simply or a provision that simply says that the purchasers of such property would have to seek their own easement if they think they need them, because apparently it's a public access road?
It does not specifically say he's barred from selling it, but it would be the latter, that purchasers of those separate lots would have to then negotiate or obtain their own easement. Essentially, if Dr. Prose sold the lots as anything other than a single piece, that lot that he sells would no longer have the benefit of the easement, and therefore would be less valuable than it would be if it had the easement. The purpose of this settlement, the purpose of the consent judgment, was to get an easement that benefits the property. And
but didn't he have no easement for many years, and yet drove on the road to and from his property without interference because it was a public road?
He did not have an easement.
Pardon,
I'm sorry, Your Honor.
No, you go ahead.
He did not have an easement when he purchased it. I don't know if we would say he drove on it for many years, because we were in this litigation pretty quickly after he purchased the property. But the problem is, this is not a public road, Your Honor. And Mr. Rosenbaum and I have sort of been trying to get anyone to listen that will pay attention to this point. This is not a public road. It's not dedicated as a public road. It is a private forest road. It happens to be owned at this time by a public entity. And it just so happens to be open to the public right now. But it is not a public road, and there is no law or requirement anywhere that it stay open to the public. And that is why Dr. Prose wants the easement. It's why he needs the easement. It's why the properties are more valuable with the easement. And if Dr. Prose went to sell, if he wanted to split it in half or split off 2 parcels and went to sell 2 parcels separately, and a purchaser came along and saw that if I buy this no longer has an easement, that property, those 2 parcels are now worth less than if they did have the easement. And Dr. Prose negotiated this consent judgment in order to get an easement to benefit the entirety of his property, which was always 5 separate tax parcels. And that was true at the time we entered into the consent judgment.
Let's look at the language, okay?
Yes.
Paragraph 4 says DNR will, to the benefit of Prose and not DNR, grant Prose a non-exclusive easement, et cetera, et cetera. What kept jumping out at me as I reviewed this case, and maybe I'm wrong because I'm no property expert, was this an easement in gross or an easement appurtenant? Nobody really seems to talk much about that. Do you think that is what we're talking about, or am I barking up the wrong tree?
So we do address that in our reply brief, Your Honor, and it's an easement appurtenant to the land. It's not an easement in gross to just Dr.
So what in paragraph 4 indicates that it's an easement that will travel with the land?
So I think, Your Honor, you have to read it in the context of the entire consent judgment. You also have to read it in the context of the case law, which basically says if it is possible, in fact, this is Penrose, which we cite in our reply brief, Michigan law favors easements appurtenant over easements in gross, and an easement will never be presumed to be a mere personal right where it can fairly be construed to be appurtenant to some other state, a state. And I think in this consent judgment, it can fairly be construed as the intent was to benefit the Prose property. And we see right in the first paragraph of the consent judgment, it says the lawsuits arise from disagreements between the parties about Prose's use of land on a peninsula within Pinckney State Recreation Area. So it's referring to Dr. Prose's land. If we look at paragraph 3 above, it refers to the purchase of additional settlement property, which is contiguous to the tax parcels, which are known as the Prose property.
Yeah, Mr. Hansma, let me stop you, because what is this additional property? Are lots 90 through 96, or a couple of those? Is that what we're talking about, or some other land that was?
So the settlement property was essentially property that goes around Dr. Prose's property that he purchased in order to resolve various trespass claims the DNR had. The DNR made claims, for example, that Dr. Prose's dock wasn't on Dr. Prose's property, it was on the DNR's property, that he had some brush that wasn't on his property. And so basically, as part of the settlement, he bought a strip of property kind of surrounding his property.
I see it pictured in white then on one of the maps here. Okay,
correct.
Thank you for clarifying.
And so, to the point I was making, Your Honor, is that the entire milieu, the entire context of this settlement is to resolve the dispute with respect to Dr. Prose's property. And the obvious intent of the easement is to benefit the property, not benefit Dr. Prose by himself. I mean, if we were to read it that narrowly, Dr. Prose's wife wouldn't have an easement right. His heirs wouldn't have an easement right. It's obvious.
That I understand isn't an issue in dispute anymore. I saw the last proposal from the state, and
that was my next point, Your Honor, is that the state's own language says it's to benefit the property. And so to that point, at the time they drafted that, at the time we entered into this, it was always 5 tax parcels. It was always 5 separate pieces of land that could be sold and developed separately. And there was no contingency, no condition, no restraint in the consent judgment that said, if you sell off one of these tax parcels separately, the easement no longer applies to that. That was never contained in the consent judgment. And it's our position that that is the effect of what the DNR is trying to do by this language. They're trying to limit it so that the easement no longer applies if it is sold separately. And our position is very simple. It's that language is not anywhere in the consent judgment. The consent judgment is an integrated agreement. It has a merger clause at the end. And therefore, the DNR just cannot impose that condition on the easement grant. And we have settled, we've resolved all of the other negotiations of the easement grant. And so our position, our request in our motion, our prayer for relief is that Your Honor enter the order we attached as Exhibit 1 to our motion, which contains an easement grant identical, absolutely identical to the DNR's last proposal, except the only thing it does is it takes out those 2 sentences in what I believe is now paragraph 4 that contains that restrictive language. That's all we're asking for, Your Honor. We think that's consistent with the language of the consent judgment, and that imposing a restriction that was never contained in the consent judgment is impermissible.
I understand. I have another question. How did Mr. Prose get to his land when the bridge was damaged?
So the bridge never was damaged to the extent that it was like in the water, but it was deemed not safe for motor vehicle travel. So
but he did travel over it?
If you drive over it, you're driving over at your own risk, and he does.
So it's the sole access.
It's the sole vehicle access, yes. The only other access is to walk through the woods or take a boat, Your Honor. And where this was particularly relevant is emergency vehicles will not go to Dr. Prose's house.
I saw that.
Yeah. So
okay. All right. And unfortunately, I'm having a little trouble finding your last version, but my clerk is with me and she'll take a look through this stack here and see if we can find it. It was your last proposal, Mr. Hansma, was exhibit what?
What we propose, Your Honor, enter is Exhibit 1 to our motion. We have a proposed order, and then attached to that is an easement, an access easement, which is, again, identical to the DNR's last proposal to us, apart from taking out the offending language, what we consider to be the offending language, and it's paragraph 5. I misspoke. I said 4 earlier. It's paragraph 5.
Okay. Well, I apologize that I don't have it in hand. We'll keep looking. Okay. All right. Let's go to Mr. Gamble for the defense, and let's listen, and then I'll have some questions probably.
Thank you, Your Honor. This really is a challenge to DNR's policy for selling easements. This is not a restriction on Dr. Prose's ability to sell his land. He can sell it to whoever he likes, whenever he likes to do so. But the DNR's policy is that if a landowner purchases an easement from DNR, that easement only applies to the landowner's parcel as it exists at the time of the sale. So if a landowner breaks off pieces of their land and sells it to third parties, then those third parties would need to purchase their own easements from DNR. This policy, as
if they need them.
If they need them, if they want them. Most people don't. But this policy is consistent with Michigan's common law governing easements. The party selling an easement can determine its scope, and this is the scope that DNR gives its easements. Now, Dr. Prose, doesn't approve of this policy, and he thinks that the consent judgment exempts him from it, but it does not.
Isn't my job simply to determine what the consent judgment says and not whether the consent judgment is consistent with DNR policy?
Yes, Your Honor, that's exactly our position. And my point is that DNR, at the time that the parties negotiated this consent judgment, did not even know that Dr. Prose wanted to be exempted from this policy. The issue never came up. He's always treated this land as a single chunk of land, built on it, designed and organized on it without any meaningful regard to these plat lines, the lot lines. These lot lines were never recorded as a recorded plat. It's just one big compound with lots of different improvements on it. Frankly, it wasn't until after the consent judgment was entered and the parties were negotiating the scope of this easement that Dr. Prose first asked to be exempted from this policy because he was considering selling off parts of his land to third parties.
Let me stop you for one moment, Mr. Gamble. Mr. Hansma, do you factually dispute that?
I do,
the
Your Honor.
Okay, then when we come back, I just wanted to see if it was you were conceding that. Okay, go ahead, Mr. Gamble.
I mean, fair enough. I never dealt with Mr. Hansma during the negotiations of this. The attorneys I dealt with never raised it. It was never a topic of discussion when negotiating the consent judgment. So the consent, it wasn't until after the consent judgment was issued that Dr. Prose wanted essentially to be treated differently than everyone else. And DNR said no, it insists on applying its policy to him, just like it does to everyone else in Michigan. So
what
really,
about sorry.
I was just going to say, Your Honor, I mean, as the court noted earlier, the issue here to decide is pretty straightforward. I mean, the consent judgment does not give him a right to be exempted from this policy. It just wasn't contemplated in the consent judgment. It wasn't discussed by the parties prior to the entry of the consent judgment. He has no legal right to the relief he seeks. DNR can apply its policy to him just like it applies it to anyone else that it sells an easement to. So since he doesn't have a legal right to the relief he's seeking, the court should deny his motion.
What about the statement in the easement that your side prepared that says this easement shall be non-exclusive and shall only benefit the property described on attached Exhibit A? Doesn't that suggest that the easement is appurtenant?
I think it does suggest that, Your Honor, but I also think that the reason for the DNR's I know the reason for the DNR's policy is because purchasing an easement from DNR is a little bit unique because you are situated in land usually bordering state land, usually a state recreational area or state park. When people purchase these easements, they need to be aware of the responsibilities associated with purchasing an easement next to a state rec area, such as you have to be on notice you're going to be coexisting with members of the public who are going to be recreating around your property. There are particular procedures for clearing the roadway if needed. The easements deal with how to resolve issues associated with the discovery of antiquities or prehistoric sites. The easement owner needs to be on notice of the need to prevent the introduction of invasive species, and also
I understand all that, but what is the DNR? I mean, Mr. Hansma kind of explains that the concern on the part of the plaintiff is he's not going to get the money for his property he'd like, and maybe the DNR is going to, make it difficult for purchasers of that land down the road. What is it the DNR is concerned about other than it's a variation from their policy, as well-intentioned and as the policy is?
Well, they want to be able to have a relationship to the people they're selling easements to. And so Dr. Prose is someone who is well familiar now with what it's involved with living basically in the middle of a state rec area. And when someone else comes and wants to, I honestly don't know where they would build this house. I mean, Dr. Prose really has established a compound out there, but apparently build another house out there. DNR needs to have a relationship with that person as well. And that person needs to enter into an indemnification clause with DNR, just like Dr. Prose has. And so that DNR can be aware of the burden that will be on this road and the people who are going to be going over there, and just monitor the situation. This is, I think I've really tried to explain to Dr. Prose's attorneys, this is pretty standard stuff. And what he's asking for is an exemption. And had they brought this up, had they brought up Dr. Prose's plan to apparently sell off his land to various people and create like a neighborhood back there prior to the entry of the consent judgment, perhaps this could have been a topic of discussion at that time and could have been memorialized in the consent judgment. They did not. And so the consent judgment does not entitle him to be exempted from this policy.
Unfortunately, I mean, it is my great desire not to hold an evidentiary hearing in this matter. But, this paragraph 4 is far from clear in terms of these questions that have now come up. And I assume the state would be opposed to this, but why can't I simply enter a judgment that said, well, there is a judgment. But I mean, why shouldn't the easement simply reflect what's written here? I realize there's something that says it has to be formalized, and I understand there's small issues, but if I'm not going to, unless I want to hold an evidentiary hearing, what can I do? I mean, you're both telling me what you meant and what was discussed, and
Well, may I speak to that? Oh, I'm sorry, Your Honor.
but let's let Mr. Gamble's got the floor, but I certainly let you speak to it. Go ahead.
So, Your Honor, I think if you could put my finger on exactly what you're referring to when you say what entering a judgment with the language.
Oh, it says, paragraph 4, it says DNR grants Prose a non-exclusive easement for vehicular and pedestrian use over the portions of Crescent Drive and Blind Lake Road within the state recreation area beginning at such a point and to his property, essentially.
Okay, sorry, you were referring to the easement document, not the consent judgment.
No, I'm referring to the consent judgment, paragraph 4.
A non-exclusive easement for. Oh, pardon me, Your Honor. I think I understand your question now. And so in our brief, we explained this point, which is that ordinarily it would be fine, I think, to have just a straightforward language of that manner in the easement. But the problem is that Dr. Prose has explained that he plans to essentially violate DNR's policy. And any future court looking at this easement is going to look at the language in the easement to try to determine what the scope of it is. And so that's why DNR, as we explained in our brief, has to explicitly put in there, we're not exempting Dr. Prose from this policy. If he sells this land to other people, or excuse me, if he breaks up this land and sells it and wants a couple of neighbors out there, those neighbors are going to have to get their own easement consistent with DNR policy. So normally when DNR is working with people and selling them easements, this isn't even an issue. But if someone in the context of those negotiations said, oh, by the way, I want to break up my land and have a few neighbors on my land, DNR would do just what they're doing here. They would put a provision in the easement that says, well, you can do that if you want, but those new owners are going to have to apply for their own easement and purchase their own easement so we can work with them directly.
So, Mr. Gamble, were you, I think you said you were not counsel for the state in the negotiations. Did I hear that right?
No, I was counsel. It was Mr. Hansma, who I did not negotiate with prior to this point.
Okay. All right, Mr. Hansma.
Thank you, Your Honor. And just to go back to an earlier, you would ask me if I disputed something factually, and just to be clear, I wasn't disputing Mr. Gamble's factual narration of what the discussions were. What I dispute was his characterization of that Dr. Prose always treated this as one single property and developed it with no intention of, in fact, the easternmost lot of the property is vacant and has always been left vacant. And my understanding was left vacant by Dr. Prose by design as a lot that might be more valuable to sell vacant rather than with structures on it. So that was my factual dispute on that point. I think that as a
so that brings me back to the actual question, which was Mr. Gamble indicates this issue of dividing and passing along the easement to the purchasers was not raised by the plaintiff in the negotiations. Is that correct, or was it raised?
I think Mr. Rosenbaum would speak to this better than I would, but I would like to, before we get to that factual question, I did want to answer Your Honor's question about how do you avoid the facts and an evidentiary hearing. And my argument on that would be there's a fully integrated consent judgment in front of Your Honor. Your Honor doesn't need to delve into who said what at the negotiations because—
Yes, but Mr. Hansma, it says neither this decree nor Exhibit B is the easement. The easement transaction will be formalized as soon as practicable. So there is a disclaimer there. I mean, I would love to just say that's the language, but I don't know that I can in light of those two sentences.
Well, I don't think you can say that this is the easement, but what you can say is this is the contract between the parties of what they're going to do, and the DNR is going to convey an easement. And I think Mr. Gamble used some words that I think is really resolves this case in reference to talking about the policies and these things. He used, and I wrote it down, he said, this is not contemplated in the consent judgment. And I would say that's absolutely right, Your Honor. It's not contemplated in the consent judgment. What the DNR's policy is not contemplated in the consent judgment. What Dr. Prose's plans for once he had the easement are not contemplated in the consent judgment. That is all parole evidence, which is barred by the merger clause of the consent judgment. What the consent judgment says is that they will convey an easement. Now, this became, unfortunately, more difficult than everyone anticipated after the fact, but the parties were able to negotiate all the other terms. There's no fight over those other terms, Your Honor. Really what it comes down to is just, is this, in conveying this easement, can the DNR now convey this easement with these restrictions and these policies that were never contemplated in the consent judgment? And the answer is no, they can't. If certainly the DNR could have said at the time, listen, this is our policy. We don't convey easements except for under these circumstances. And if you want to pay for an easement, these circumstances are going to come with it. And if you're not agreeable to that, then we're either going to come up with a different settlement, or we're going to go to trial, or we're going to do something else. The DNR.
Well, I agree. It would have been nice if someone had raised the issue during the discussion. So let's go to Mr. Rosenbaum for just a moment and hear what he has to say about that.
Thank you, Your Honor. And I think Mr. Gamble will confirm I was the attorney that dealt with Mr. Gamble during the negotiations. And I can tell you absolutely the DNR's policy was never raised during the negotiations. So when Mr. Gamble says that we should have asked for an exemption from the policy, it's difficult to raise and seek an exemption when you don't even know that such a policy exists. And yet the DNR knew full well there were 5 separate tax parcels out there, which raises the possibility that somewhere down the line, they always could have been sold off separately. He always had the right to do that. But, and had the DNR said to me, we have a policy, you've got 5 lots, and just to be sure, certain, we have a policy against giving an easement that would benefit the 5 separate lots if he subdivides them, then we would have had such a discussion. But it was never raised. My intention was, as Mr. Hansma pointed out, from the first time we ever had a dispute with the DNR, was getting Dr. Prose access to his property writ large. All the lots. He had 3 separate structures. He had 5 lots, and the only way to get to them was over state.
I mean, he has access to all 5 lots, doesn't he?
At the time of the settlement, he only technically had access to the lot up at the top of the hill, if you will, because the road ended at that point. He had no vehicular access to get down to his boathouse and to his cottage. That's the reason that we had the settlement where he purchased the property surrounding, which then gave him the vehicular access to get down to his cottage.
But
So
once there's an access road, as there is, that leads onto the property, meaning all of it, then isn't the access to the other lots a question of him putting in private driveways within his property?
But certainly the road that exists now, as Mr. Hansma pointed out, is not a public road. It goes over state land. It can be closed off by the state at any point. My only concern was making sure that road stayed open to get to his property. What I'm hearing now is that, and so now the easement accomplishes that. The easement legalizes that consent access that we've had all these years. But what now I'm hearing is that if he chooses to sell off, let's say, the lot on the most eastern part of the property, and somebody wants to build a road, somebody wants to build a structure there, even if he puts a driveway in, okay, it goes from maybe his lot to that lot that he's selling off, the DNR is saying, we're not going to let those folks come across the bridge and across our land to get to that new house because the easement doesn't benefit them. That's what I'm hearing from Mr. Gamble. And that's not what we negotiated. What we negotiated was all of the lots get the benefit of the easement. And that was the only discussion we had. Policy was never raised, so I couldn't ask for an exemption because he never said we had a policy in case Dr. Prose wants to subdivide. I didn't say he was going to subdivide. I didn't know if he would or wouldn't, but he did.
Well, why kick the sleeping dog, I guess, right?
What was that, Your Honor?
Why kick the sleeping dog, I suppose?
Well, it just wasn't something that was contemplated by either of us.
All right. Okay, Mr. Gamble, do you want to respond to any of that?
Yes, my response is that, I think the court put your finger right on it at the beginning of this hearing, which is that DNR is not telling Dr. Prose's future neighbors that they can't access their land. The whole point is that they can. All of Dr. Prose's neighbors access their land right now without an easement. Dr. Prose is the only one who wants one, and he bought it. We're trying to sell it to him, but if his neighbor wants one, they can buy one. They can go through the application process. So it is not correct. It is absolutely not correct that if Dr. Prose, gets some neighbors out there and sells off his land to one or two people, that DNR is going to prohibit those people from driving on publicly accessible roads to access their land. That is not true. And so that's not the point that is in dispute here. The point is just, if Dr. Prose wants to sell his land to people, do they also have to apply and purchase an easement? And DNR's position is yes, that's statewide policy everywhere else. It doesn't apply differently here.
I understand it's statewide policy. Is it legally binding?
Yes.
I mean, and then you have to educate me a little on administrative law. I'm sorry.
Well, my point is simply that this is what the state real estate office would do in any other situation. So if someone, up north, they live on land that is mostly surrounded by state land in a rec area or state park, usually they can just cross open roads to get to their land. If they want an easement, they go through the application process. DNR uses their standard form, which we have substantially, negotiated over the past 2 years.
I don't think I've seen that form. Is it in the record? Do you know?
No, I don't believe. It's just online. We can just send the court a link if the court wants to look at it.
I would appreciate that. Of course, copy the email to opposing counsel.
Of course.
So what's in this application? I mean, in other words, let's put the money aside for a moment. You mentioned a couple of things. The DNR wants to make sure that they understand, there's antiquities and there's other issues that might arise, particular to a state park.
Yes.
Is there anything else that's in there? I mean, I'll look at it, but I want to get a sense of it.
I don't think the application necessarily will spell out this scenario, because the application anticipates a single landowner purchasing land, and there's the standard form, and I can send the court an original version that was sent here, or that was sent to the parties here. The standard easement document actually has a bit of a harsher penalty. It says if you subdivide your land after buying this easement, the easement's void. And Dr. Prose wanted to negotiate that, which we did in this situation. But
well, if you negotiated it, where is the result of the negotiation?
Well,
because that seems to be the crux of the case, right?
Yes, the result of the negotiation is that we probably had 18 disputes over the course of the past 2 years, and we've whittled it down to this one. And this is a point where DNR is been willing to kind of bend to Dr. Prose in some respects, but this is one where they say, no, if your neighbors want an easement like you have, they can buy one. And we need to be able to work with them directly, and they need to be involved and understand the responsibilities associated with that process. And they also need to indemnify the DNR. And so that's really the key here, is that, had this come up where Dr. Prose explained his apparent long-term plans, which we did not know about, that he was planning to sell off portions of his land to neighbors and create neighbors out there, we would have talked about it back then. But really, the issue here for the court is just, does the consent judgment give Dr. Prose a right for this policy not to apply? And it doesn't.
No, but the problem there, Mr. Gamble, is that the bare bones of the consent judgment doesn't speak to any of those conditions that you put in the easement grant. So I don't know how relying simply on the language of the consent judgment helps you much, since all of that language isn't reflected in it.
I mean, our perspective would be that the general laws and practices of state agencies continue to apply unless the consent judgment says they don't. And since it doesn't say that they don't apply to Dr. Prose here, then they would.
Except
Okay.
for Your Honor, I think Mr. Gamble's somewhat admitted the policies of the DNR in negotiating these things apply until the DNR decides to do something different, because he said they negotiated some things that ordinarily they would insist on that they didn't insist on. So the DNR is perfectly capable of enforcing this policy or not. It's not a policy. Any of these policies are not legally required. That's what the DNR would typically do. And my point is, Your Honor, they entered into a consent judgment where they failed to preserve any of these policies and say this easement shall be subject to DNR standard policy relating to X, Y, and Z. And
well, what are they supposed to do if down the road, Dr. Prose sells an area and that new owner doesn't adhere to the standard requirements of an easement from the DNR that Mr. Gamble has described? What remedy then does the state have?
Well, so they would be bound by the provisions of the easement grant that is negotiated with Dr. Prose because it runs with the land. So they would have the same benefits and burdens of the easement. It wouldn't be a free-for-all, Your Honor, where they would just have this absolute right to do whatever they want, wherever they want on this road. They would be subject to the same easement grant that Dr. Prose is subject to because it runs with the land.
Okay.
I mean, Mr. Hansma is confident that Dr. Prose's potential future neighbors have also agreed to indemnify DNR. I'm not as confident about that, Your Honor.
Is that in the easement grant?
Yes.
And what, in other words, you think their position will be, I'm not subject to that because why?
Because they didn't agree to it. Dr. Prose did.
But if they're getting an easement that runs with the land, aren't they bound by that?
Ideally, but the point is to try and diffuse these sorts of conflicts beforehand. That's why the DNR's strong preference and policy is to work directly with easement purchasers rather than, the neighbors and the neighbors of the neighbors of the easement purchasers about these disputes that their neighbor 20 years ago agreed to that they didn't necessarily agree to or were necessarily aware of. So, okay.
Anybody want to say anything else before we conclude? I'm not going to make a decision today. I'll issue an opinion. It's a difficult case. I presume that all attempts at settlement negotiation are long exhausted.
No, and I should say, I think the parties have actually done a pretty good job of keeping this case out of court. And we've really managed to resolve a lot of our disputes. We had a short mediation that helped. And so, I know that Dr. Prose, wasn't eager to get this in front of court. This is just a genuine area of dispute here. So,
well, I'm just throwing this out. I'm not trying to settle your case, but has there been a discussion about whether there could be language, assuming that he could alienate the property and grant and pass along the easement, any language that it's subject to agreement to DNR requirements regarding people who hold easements? In other words, that he can't sell it to somebody who's not willing to sign off on whatever the DNR tells you have to do to have an easement there.
So to answer your question, no, I don't think we've specifically discussed it in that context, and I don't think I'm in a position to even answer Your Honor's question because I would need to confer with Dr. Prose and the real estate counsel, who I am not. I didn't draft it. I didn't do the drafting in this. So.
Okay. And Your Honor, I just before the record closes, I just wanted to note that the DNR had also filed a motion to enforce.
Yes. And I mentioned that at the beginning. Yeah. Do you want to speak to that separately? It seems to be the same, but.
No, I think it is. I think they are distinct issues because the.
Oh, you want to enforce the sale at least? Yes,
because purchasing the land surrounding Dr. Prose's current parcel, from the DNR's perspective, is a different transaction. The easement purchase is separate from the deed of the land. The deed has been finalized for almost 2 years, since October 2021.
Has the $400,000 been paid?
No. And so the
195 was paid.
Yes. So the 195 was paid for the easement. We're trying to close on that or get that resolved. The deed has been final for almost 2 years, and we've tried to persuade Dr. Prose to just finalize that transaction. and he has declined to do so, which is why we brought our motion to enforce. And so our position is explained in the brief. I think it's a fairly straightforward, discrete issue.
Okay. Anything else?
I can just speak to that last, the DNR's motion. I think our position set forth in our brief pretty thoroughly as well, so I won't spend a lot of time, but really 2 points. I think that when you look at the consent judgment, the entirety of the consent judgment in context, the sale of the what's referred to as the settlement property and the conveyance of the easement are really intended to be part of the two parts of the same transaction. They both refer to being done at the same time as soon as practicable. And really, it's our position, it's not practicable to purchase the property until the easement is complete. One, why would you purchase property when you're still fighting over your access rights and you don't have your access rights? So they're clearly meant to go together. And then just in terms of the consent judgment talks about formalizing the transactions. And in terms of formalizing the transactions, part of that would be a closing with title insurance, which Dr. Prose intends to do. And part of getting all that title insurance and things like that together is having both the purchase and the easement grant done together. And again, I think all of this is explained in our briefs, Your Honor, but I'm happy to answer questions.
My recollection is the title company isn't requiring that, but you feel it's needed to assure no problems in the future.
Correct. Otherwise we would have negotiated for a warranty deed, which we did not. And since we're getting a quitclaim deed, which in this context is perfectly fine, as long as we can get title insurance, which will require us to get the easement lined up as well. That's our position, Your Honor.
Well, but that's my question is, I know there was a couple of pages from a dep of somebody from the title company, and my recollection is they said people could get title insurance for these other lots without an easement. Is that incorrect?
And that's not my recollection of the dep testimony, Your Honor.
Okay. All right. Anything else?
No, Your Honor, not for me.
Thank you, Your Honor.
Well, I just want to thank you all for putting this one in my lap. It's you know, I guess this is what happens when something at the end comes up and everybody figures it's going to work out, and sometimes it doesn't. All right. Well, I'll do my very best, and we'll hopefully get something to you in the next month.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. Thank you all. Bye-bye.